Good evening. Good evening. Hi, my name is Michelle Phillips. I am here from the Department of Public Service. I'm the administrative law judge that's been assigned to conduct the public statement hearing. Prior to the public statement hearing, we're going to have an informational session. During the informational session, we will have a presentation concerning the process that will be presented by Mr. Graham Jessner. He's one of the attorneys at the Department of Public Service who's going to be reviewing these cases. He's sitting to my right. We also have individuals here from the applicants, the people who applied to both operate the electric plant and to construct and operate the gas pipeline. They will also be doing presentations. The first one will be an overview by Dale Irwin, and the second one will be discussing the pipeline by Mr. Joel Moore. Basically, during this time, I ask that you turn your attention to the speakers. They'll do a brief presentation. There should be time remaining to ask questions about the applications. Just to clarify again, though, process questions should go to Mr. Jasper. And any substantive questions about either the plant or the pipeline should go to the representatives of the applicant. Are there any questions before we get started? Okay, thank you very much. No, there should be time for questions. Yes, I believe about 10 minutes and maybe another 10 minutes with the company. We should leave roughly 40 minutes before we have to start the public statement hearing. Okay?
Thank you, Judge Phillips. So, good evening, everyone. My name is Graham Jessner. I'm an attorney with the Department of Public Service, assigned as part of the staff team that will review the cases that we're here to discuss tonight. I'm going to give a brief overview of the review process, how that works on both the staff level as well as the commission level, and then I'll turn it over to the applicant. Hopefully, we'll have plenty of time. We'll definitely have some. So, to start, the applications were filed under Section 68 and Article 7 of the Public Service Law, and I'll get into what those mean in just a second. The Public Service Law, Section 68, was originally enacted by the legislature way back in 1910, and then recently amended. In short, it requires a petitioner, in this case Greenidge, to obtain a certificate of public convenience and necessity, or we use shorthand as CPCN. That certificate allows them to operate a generating facility. It's declared to be in the public interest if they were given that certificate. Article 7 of the Public Service Law was enacted in 1970, and this is the statute under which the Department and the Commission review major electric and gas transmission facilities, so transmission lines and gas pipelines. So this section, or this article, requires an applicant to obtain the CPCN that I just mentioned, and to meet various requirements prior to construction. We'll go through some of those in a minute or two here. So a little bit more background. The Section 68 review process examines the need and the feasibility of the project. So it's designed to ensure that the activities that are being proposed, the actions that are being reviewed by the Commission are necessary and, as I stated before, in the public interest. So once a right, a privilege, or a franchise under Section 68 has been granted to an electric or gas corporation, they can provide service, and in this case it would be to operate the plant. Under these sections, the following sort of things are considered: the construction of electric and gas plant, that is the physical assets. Here, we'd primarily be just discussing the pipelines, the plant is already in existence, except obviously where Article 7 applies, and that's the transmission line. And then it's just the exercise of any right and privilege. And that's just legal terms for if they get the approval, they can operate the facility. So Article 7 is designed to provide a forum through which an open process can take place that resolves a number of matters: environmental, technical, and it involves a diverse range of participants. That includes citizen interest groups, municipalities, and state agencies. There are required parties under Article 7 that include the Department of Environmental Conservation and others, and I'll get to those in a minute. Article 7 applicants are not subject to the State Environmental Quality Review Act. However, they do have to provide the Public Service Commission with very detailed environmental analysis of the action they propose. They are required to minimize environmental impacts of any action proposed, and the process is designed to allow for full public participation. So I'm going to walk through each section now in turn, section 68 first. So in order to have a complete application for the commission under section 68, and to have the commission approve any pending section 68, a corporation, in this case Greenwich, would have to show that the organizational charter empowers them to operate as an electric company, that they've received consent from municipal authorities, that the enterprise is financially viable, that it is able and willing to render service, and the enterprise is overall in the public interest. These are sort of the threshold questions under section 68 in order for the commission to be able to grant a CPCN, as I stated earlier. If a petitioner in turn requests construction approval, must also describe the plant that they propose to construct. So under section 68, Greenwich Generation LLC has filed petitions in two cases, 15E0516 and 15G0571. Department of Public Service staff, which includes myself, has been assigned. It includes engineers from our gas safety and gas policy section, environmental specialists that will look at any construction plans, legal counsel, as I said, myself, and another attorney who couldn't make it tonight, consumer outreach specialists, and finally the administrative law judge, Judge Phillips, who introduced the proceedings tonight. There will be a procedural conference next week on November 10th in Albany. For those who intend to become parties to the case, I encourage you to do that as soon as possible in order to take part in any procedural conference. Decisions on the Section 68 petition. The Public Service Commission will review the record in the cases. That includes any material submitted by the applicant, as well as anything that staff asks for and puts into the record for review, including the transcript here tonight. So during the public statement hearing portion, any comments that are made will be considered part of the record and will be before the commission when they make their decision. The commission has essentially two decision options. They can deny the petition or grant the petition with appropriate conditions, depending on the request that's been made. I can't speak for what the commission will or will not do, but those are the two options that would be before it. In terms of decisions and findings under Section 68, after due hearing, the commission may grant CPCN if it determines that, as I said before, the exercise of the right or privilege is convenient, necessary, and in the public interest. The commission must consider the economic feasibility of the corporation, as I again stated before, and then finally they have to consider whether overall the entire grant of authority is in the public interest. The Article 7 application, by contrast, was filed by Greenwich Pipeline LLC and Pipeline Properties Corporation. This was filed pursuant to Section 121A3 of the Public Service Law. That section applies to gas lines less than 10 miles in length, or if it's greater than 6 inches in diameter, which isn't the case here. Greenwich Pipeline proposed a project about approximately 4.6 miles in length and 8 inches in diameter, so it falls under Section 121A3. Operated at a maximum pressure of 1,400 pounds per square inch, and then it would start, and the company will get into this in more detail, but it would start at the Empire Connector pipeline and then connect to Unit 4, the Greenwich Generating Facility. The filing requirements for 121A3 include the following: the location of the line, a description of the facility proposed to be built, why the facility is needed, a description of a host of environmental factors, including the local ecosystem, local land uses, visual, historical, cultural resources that may be affected by the line, agricultural uses, essentially any environmental impact the line would have to be explained in the application. The following, the application process, any approved environmental management construction practices have to be followed. Those are proposed by the applicant and signed off on by the commission if it gets to that point. Those procedures and practices are designed to minimize and/or completely avoid environmental impacts to the maximum extent possible and practical. Other information considered relevant by the applicant is also filed, and then any other information required by the Commission's regulations. This includes mapping details and a host of things that you can find under the case number I mentioned before, on the Commission's website. So the applicant is required to and has served the statutory parties, which I briefly mentioned earlier, but we'll run through now. They include the State Department of Environmental Conservation, or DEC, the Department of Agriculture and Markets, any municipalities in which a portion of the line will be constructed, and then finally, other persons or entities that the Commission deems appropriate. No decision has been made as to any other parties at this time. In terms of the process and the timing for the Article 7 application, it was filed and docketed under case 15T0586. Again, we have a host of specialists from the Department of Public Service assigned to review. The application is reviewed first for compliance with the Public Service Law and associated regulations, and then any deficiencies are identified to the applicant within 14 days of the filing. We've done that. The applicant is in the process of supplementing the application. No deficiencies have since been identified. The Public Service Law requires the Commission to make a determination within 60 days of receiving a compliant application. It may be extended where the PSC has a hearing. This hearing has essentially pushed the pause button on that 60-day clock. The fact that we're here tonight extends that time frame for Commission review. Under Article 7, the Commission will review the entire record, including the application, again, the transcript here tonight, and any comments received through the Commission's website. The decision options here are a little more nuanced. The Commission can again deny the application or grant with appropriate conditions. And here, appropriate conditions generally include environmental impact mitigations, alternate locations or routes, or alternate designs for a given pipeline. Those conditions are typically explored through the review process with staff and the applicant and the other statutory parties, including the DEC that I mentioned earlier. So in order to grant an Article 7 application, the Commission has to make the following findings. They have to find a basis for need for the facility. They have to find the nature of any probable environmental impacts, that the location of the line will not pose undue hazards, that the facility conforms with applicable state and local laws, except for any substantive local laws found unreasonably restrictive, which the Commission is empowered to waive. And then finally, the construction and operation of the facility is overall in the public interest. So following any approval of the Article 7, I know I'm going quickly, but I want to make sure that everybody has time to ask questions. Rights of way and access acquisition would follow. You'll hear some of that from the applicant. Construction would then occur. The first step is clearing, grading, and then facility construction. Environmental controls are undertaken, including erosion control, traffic control, dust management, others depending on specific locations and soils and what have you. And then finally, follow-up measures would come into play, which is restoration and re-landscaping, any drainage repairs that would have to take place. So I know I threw a lot of information at you, and I'm sure you're anxious to hear from the applicant about what they're actually proposing, but I'll be available to answer any process questions. There's time after the applicant or following the information session portion. But very briefly, this is the way that you can comment. If you don't want to make a public statement here tonight, you can file comments in the Commission docket using either the website or email, or sending written statement to any of the addresses here. I want to run through that. I'll leave this slide up on the screen while the applicant does their presentation, just so nobody has to write it down very quickly. So at this point, I'll turn it back to Judge Phillips.
Does anyone have any questions about the process? I know we went through that quickly. Yes.
You talked about both section and Article 68, requiring the applicant to show this is in the public interest. Could you explain what criteria you use to determine that something's in the public interest?
Sure. In this context, the public interest standard is flexible and depends entirely on the record in front of the Commission. Typically, in generation scenarios in the past, the Commission has found that if the applicant meets all the requirements under Section 68 and that the ISO has approved of the facility going into operation, that generally, because they're wholesale generators and they're not guaranteed any return, that the operation is therefore in the public interest. It's a lower bar than in some other contexts. So think that answers the question. As far as the pipeline facility goes, that's a very case specific and entirely depends on the reason for the pipeline and where it's going. And I'd encourage you to do a little bit of research. I can't go through all of it tonight, I'm sorry. Anyone else on process right up here?
How often has an application been denied?
In my, albeit very limited experience, I have not seen one denied. Judge Phillips may be able to.
Are you asking Article 7 or Section 68?
68.
I don't want to hazard a guess. I would have to maybe do some research and get back to you. I'd have to check. Right, that's you mentioned Article 10, which is a slightly different statute, deals with plants over, now it's a certain size.
Article 10 has historically now deals with the siting of new generation facilities, and there have been applications denied under that statute. Section 68 is a much more bare bones licensing statute. The bar is the findings that have to be made are very ministerial in nature, which is what I kind of ran through. It is more typical for projects to be amended in the Article 7 or Article 10 phase.
And I think too with the, I'm sorry, can everyone hear me okay if I'm not using, oh, sorry. I think too with Section 68, I think just to clarify, what we're looking at when we look at the Section 68 is the operating of the plant. In the E case, the E5106, is what they have to show in order to be approved to operate the plant. For the gas one, it's the operation of the gas line. For the transmission one, which has the T in it, that's the one where you look at the environmental impacts more in detail, because that's going to examine, is this an appropriate route? What are the environmental consequences associated with constructing the line? So it gets more into the construction of it, whereas the Section 68s are going to be looking more at how are they going to be operating? Do they have, are they fiscally responsible, financially able to do what they say they're going to do? So it's more operation. It's kind of, and with the plant here, it's an existing plant. So it's basically upgraded, and then how will they be able to operate? Will they be able to operate responsibly? Would it be in the public interest to approve that? So I'm going to let you talk when we get to substantive, or I'm sorry. Do you want to? Okay.
The question, first of all, I'm George Pond. I'm an attorney for the applicant, and I handle matters in front of the Public Service Commission. I thought you might be interested in a couple of cases. I know that NYSEG had a Brothertown Road line extension that the commission rejected. I don't know if it was an Article 7 or 68.
Is it a pipeline now?
No, it was an electric transmission line, but Article 7 applies to electric and gas.
And I'm just asking about Section 68 though.
Or specifically about Section 68 and not Article 7? Okay, well, as the judge said, that's a different threshold.
One other
And there's another question.
In considering environmental impact, does this process consider methane leak?
I'm sorry, can you say that again? I couldn't quite hear.
Does it consider methane?
The process considers environmental impact of the project. Does that include methane leaks?
In terms of the construction and operation of the pipeline, yes, it would have to be reviewed by our gas safety staff, technical staff, to determine whether, in DPS staff's opinion anyway, there was little to zero risk of leaks from the pipeline itself once it was in operation. And I've got one more back here, it looks like.
One of the items you suggest that has to be reviewed is basis of need. Has that been established?
So in terms of the review process, it's for the applicant to demonstrate in their application why the facility is needed. In this case, the transmission pipeline has to get looked at in terms of need. On the Section 68 side, again, it's a different set of criteria that looks at how the company would operate the facility.
But it doesn't then explore the actual need in terms of the community need?
If the applicant puts that information in the record, if another party puts that information in the record, yes, it's examined.
It will be examined because the applicant does make its argument with respect to why it thinks it's needed. As Mr. Jesmer was discussing, other parties may come in and they may have a different position, and then that will get evaluated. But in terms of whether that's been determined yet, no. It hasn't been determined yet. The commission hasn't made a decision yet.
Thank you.
There's one more over in the back, I think.
Yeah, you said that this process of the hearing puts a pause on the process. Could you elaborate on how long that pause is?
I'm not aware that there's a definitive time frame. Typically, we try to use 11 months as some kind of criteria, but Article 7 applications can and do routinely go on for a very long time. We have cases in process right now that have been pending for 3 and 4 years. It just depends on the nature of a given case. I have one more up front here.
Yeah, about the same, topic. Did you mention 60 days only for the 2 articles? There's only 60 days up to the process.
So for the pipeline application, because of the section that it was filed under, there's a starting point of a 60-day review period. If a hearing is held, and that hearing is being held here tonight, that 60-day window is stopped, and the application can be reviewed for a longer period of time by the commission. So that's where we are now. There is no 60-day clock that is now in play because we're here tonight. I've got one more in the back, and I'm going to have to turn it over to the applicant.
Yes, I'd like to know what sort of assessment will be done of environmental risks posed by the coal ash landfills. So we know something about the Lockwood coal ash landfill, and we know that at least 6 acres of that are unlined. It has a soil liner, which is an oxymoron. There are old, but the plant itself began in 1937, and the Lockwood landfill began in 1988. So we have many decades of coal ash disposal apparently around the environs of the plant. That needs to be checked for contamination because it's putting Seneca Lake at risk, and 60,000 or more people drink that water daily. So how will that be addressed, please?
The existence or continuing operation of any coal ash disposal is not part of the review in these cases. These cases are very specifically geared towards can the applicant, Greenwich, be given permission to operate the facility and to build a pipeline. If you have concerns about how those coal ash disposal sites are being maintained, I'd encourage you to talk with the applicant and or with the Department of Environmental Conservation, as that would fall under their purview and not the Department of Public Service.
But in my humble opinion, sir, I would think it's prerequisite that the new owners be required as a prerequisite for opening the plant, reopening it, to deal with the existing contamination threats, which are legendary because there are no liners into these old, decades of coal ash disposal.
You're free to put those comments into the record both tonight and on a going forward basis, but in terms of the statutory findings that the commission has to make, there are no findings required with respect to those sites. So I'm going to, in the interest of time, turn it over to the applicant here to give their presentation, and they may be able to answer more of your questions than I could.
Will there be opportunity following your presentation for more questions?
I'm trying to make sure that there is.
Right now, I have 6:26, so if they take about 10 minutes, there should be additional time left.
Hi, everybody. I'm not as well versed as the honorable and the attorney, but my name is Dale Irwin. I grew up 6 miles away to the south on Seneca Lake. Grew up in Seneca Lake. I love Seneca Lake. It's hard pressed to find anybody else in the summer on Seneca Lake more than I am. My family is on Seneca Lake. I love Seneca Lake. It is part of me. So I really appreciate everybody caring so much about Seneca Lake. I'm also president of Greenwich Generation and the Greenwich Pipeline LLC. Like I said, I grew up. I graduated from Dundee. I have dozens of relatives in the area. If you ever see an Irwin with an I, that's my relative. And I've been, after I got out of the Army, served in the great country of the United States so people could voice their opinions. I got a job in 2001 at the Greenwich Power Plant. I worked there since continuously without a day off since 2001. Well, took some days off. I just want to say, you know, the power plant is a staple of this community in Dresden. It's been here since the 30s. It used to be the largest power producer in the area. I've been through some real good times, and I was through the worst times with the power plant. And I'm excited to see it come power up so our children and their daycares can have electric, our schools can have electric, the hospitals, so the ventilator on my grandmother will still work. I really seem to think that there's a real need for power generation. Just to tell you a little more about the applicant, Greenwich is owned by Greenwich Holdings. Greenwich Holdings is owned by Atlas Holdings out of Connecticut. Atlas finds very companies that are on their last leg, and they step in and they really save them. They're two individuals that are remarkable that manage the Atlas Holdings. They stepped in Glen Falls, and Glen Falls is going to lose their biggest employer in the region and bought Finch Paper. They're the only ones that would save 600 jobs. Next year, they're planning on investing, this was 8 years ago, next year they're planning on investing another $23 million into that facility, increasing the employment in that area. They turned over thousands of acres of forest to the Natural Conservatory in New York. Atlas is a fantastic story, and this community, in my opinion, is lucky to have them as a partner, and that's really what they are. They are a partner. Anybody that's worked with us, we've been working on this project for 2013, 2012. We've been engaged with Atlas. We've met plenty of the government officials, the mayor, and we have an outstanding rapport because we understand we're in a partnership with the community also. We go out of our way to be good neighbors, and we want to continue to be good neighbors. But let's get on to some questions here. I just have to say that we're seeking to resume operation of the existing power generation station and to construct a 4.5-mile pipeline. Unlike a lot of the projects that we see in New York, we are not asking the ratepayers to pay anything for us. We are self-funded. We're going to pay for the pipeline. We're going to pay for the Greenwich restart. We're not asking the PSC to do special rate case for us, the ISO to do a special rate case. We feel that this plant has a lot of merit. It has a good economic future, and we're excited. The initial resumption of electricity hopefully will start this spring, It'll start on the existing natural gas system that's there. We have a biomass handling system that will be burning biomass in addition, and just a small amount of number 2 fuel oil just for flame stabilization. The plant has been inspected by the New York State Department of Environmental Conservation, and they were impressed with its condition. We've had several General Electric in. General Electric has done numerous tests on transformers, generator turbine. They're impressed with the condition of the whole facility at General. As soon as possible, we'll be constructing a pipeline and then converting the boiler system to burn 100% natural gas, and then we'll have the ability to coal fire up to 10 to 15% with biomass. We will be putting good paying jobs back in the community. We will be increasing the tax revenue right off the start. And, I hope some of the 40 people that got laid off 3 years ago because of the downturn in the economy can come back to work for us. It's pretty hard to see them, knowing what their families are going through, going from a job like Greenwich offers to what's out there, the jobs that are out there. It's hard to see the things that their family are going to go through. I know I had a lot of friends move away, and I hope I can do my best to get this plant up and running so we can bring them home.
Is there someone who's going to speak about the pipelines?
Joe Moore, he left. Joe is from Integrity Engineering. I think he laid the first pipeline that was ever built in the United States. He'll be speaking about pipelines.
So just a time check, about 3 minutes, and then questions?
Oh my, you asked the wrong person for 3 minutes.
For him or me?
You.
Oh, me?
Took your time.
Okay, well,
Keep it short.
Okay, so looking forward to lots of questions. Thank you, Your Honor, members of New York State Public Service Commission, and all of you folks that are so interested in all this. It's great to see. My name is Joel Moore. I own a company called Integrity Engineering. I lived in 20 years town of Reading, moved to Odessa just a little bit ago. I'm not going to tell any more about myself. I have 8 daughters. How's that? So that's why I look the way I look. So it's a 4.6 mile nominal 8-inch diameter steel pipeline. Mostly 1/4-inch wall. Railroad crossings and road crossings will be a little bit extra heavy pipe. We have exceeded the requirements by various state federal codes for the strength of this material. So essentially we have a higher factor of safety than would be required. Welded construction, it's all steel. There's a piece of 8-inch pipe over here behind the curtain. If you'd like to see something, it's kind of a chintzy looking piece of pipe, but it's pretty close to what it's going to look like. A little better condition. Fusion bond, it's got a coating on it so it doesn't corrode, and we have magnesium anodes on it, so it's all kinds of regulation and requirements to protect that pipe as we maintain the coating and the cathodic protection. The pipe should last forever. But somebody digs into it. Approximately half of the route is in agricultural areas. How am I doing on time? Okay. Permanent right-of-way is 50 foot. We have a temporary workspace of 80 feet total. Total of 80 feet. A little bit extra at roads, streams, places that we need to do that. More room. Have some temporary access roads. Be constructing the cap and meter facility on the 24-inch natural gas pipeline. The Empire Connector runs from Rochester to Corning. Tap is on Himrod Road, town of Milo. Empire Connector operates at approximately 800 psi. We'll be designing 1440 PSI. Someday, whenever they may increase the pressure on their line, we won't have to put regulators in that location. Various equipment at both locations. So in Rod Road, there will be a small building. It's about 100 by 150 foot site. There will be a small building with some electronics in it. It's a fenced area. There will be gas meters, various piping above ground. It's kind of hidden down behind the barn. It's kind of a really nice location that we have. At the plant, there will be gas regulators, a gas heater, and again, another building for controls. You want to jump right into questions?
Yes, please.
Questions for him? No, go ahead.
I'd like to know how long this boiler has been in operation, when the last time it had a technology upgrade, and whether it really is as efficient as modern day gas generation.
I'm glad you asked that. This boiler was put into service in 1953. It last operated March 18, 2011. In 2006, we spent over $40 million upgrading it for NOx control, SO2 control, baghouse, mercury control. We had a state-of-the-art system. Now running, transitioning over to clean burning natural gas. We will be even cleaner now. Its heat rate is competitive with what's in service today. If it wasn't, there wouldn't be a good business case to start it up. I would just, yeah, as soon as she points to you, just start asking.
I've got a twofold question. First of all, can we see that pipe more clearly? It's the green right here, right?
It is. Bring it up.
I don't like the fact that it's hidden by the screen. My next question is, the upstate, well, I mean, for all, I've already seen up close.
Okay.
Thank you. The upstate region, according to the New York ISO's 2015 report, has a load of 10,000 megawatts and a total of 18,000 megawatts. Nearly twice what is needed. So is this electricity really needed by
The schools and daycares and your house?
No.
Well, let me just tell you some facts.
Excuse me, sir. You didn't let me finish
You
my
just
question.
asked me a question. Is it really
I wasn't
needed?
done finishing. I said,
Oh, I'm sorry.
by the state of New York. Is it needed by the state of New York?
If it's needed by, well, the gross load in New York, the height is over 35,000 megawatts. Central region is different, but if you're asking about New York in general. In 2015, the ISO also published a report that said that Greenwich Station is very favorable to voltage support in the area. So I would say, if you know anything about electricity, you know voltage is an important element of electricity. Yep.
Yeah, if I can take a shot at that. The way the electric power system in New York works, it's administered by the NISO. I think you're aware of that. And it's a bid-based system, and generators bid to supply. And obviously, everybody wants prices for electricity to be as low as possible. It works like any other competitive market. If you can sell your product into the market for less than anybody else, you can make money. If you can't, you lose money. Dale just said we've done an economic analysis, and this plant will make money. It will, while it's making money for Greenwich, it will lower electricity prices for everyone else. So it's a classic example of competitive market forces in operation. Thank you.
Thank you.
In the back, and then over here.
I have a follow-up to that. In terms of its economic profitability and the times that you envision it operating, is it going to be operating as a peaker plant, base load plant? What do you anticipate anticipate its capacity factor will be? How long will it operate?
Will be dispatched by the ISO in the day ahead, hour ahead markets.
And what do you anticipate its capacity factor will be?
I would anticipate the capacity factor anywhere from 50 to 70%.
50 to 70%. And that's based on their reliability in the area, or is it based on?
It's based on a backcast of taking how much it would cost us, our variable cost to make a megawatt of electricity compared to what the ISO has sold electricity or bought electricity for. And if we do a backcasted analysis of that, it shows that our plant will run 50 to 70% and be very profitable in the state, in this location.
But there was, okay. I'm wondering, with the pipeline, how have people given permission for that to be on their property, or has that not been done yet, or will it be taken eminent domain? How does that work?
Like I said, Miss Gaines, how are you?
I'm fine.
Okay, thank you. Look, we have to secure rights for our right of way, and we have been working with the landowners, I don't want to say from day one, but right steady. We have a very good relationship with all the landowners along the routes. And I would say, what's our count on how many landowners that have signed a right of way agreement? At least we're over halfway, and we're making very good progress on the other half.
Will the rest be by eminent domain?
We do not anticipate that they, or even consider taking any from eminent domain.
What plans do you have for monitoring methane leaks, both in the pipeline and at the burner tip and throughout the plant?
Right. So at the burner tip and within the plant, methane leak is a pretty dangerous thing. So typically methane monitors, etc. But we're really concerned with explosion issues at that point. And so explosive range of natural gas in air is 5 to 15%. And this gas will be odorized at the tap at the meter facility. We utilize, when you hear about methane leaks, most of that in the system in the world is either like a blowdown on a compressor facility or a leak on older piping. And so the fact that this is all new, and most of that also is low pressure piping. Original gas systems that operated at the quarter PSI. And so cities like Elmira and Corning and Geneva have a lot of that and have a lot of low pressure leaks on that. We wouldn't have that on this pipeline. A very, very small hole at 800 PSI makes a very big hole in the ground, and that's where national news is made. So that's where it gets into proper materials, engineering, design, inspection, etc.
Are you monitoring for methane below 5% in the 2 or 3% range, and are you measuring it along the pipeline? I'm asking, are you going to be able to know what the greenhouse gas footprint of this facility and the associated pipeline will be? Will there be monitoring?
Will there be monitoring? No, there wouldn't be monitoring. You wouldn't monitor a pipeline for a week for any purposes other than an annual survey, which we perform. The 255 code, which is over here someplace, requires certain inspection and criteria on an ongoing basis for leak detection, if you will. And you physically walk over the pipe with a hydrogen device that looks for parts per million of leakage on that. But again, the reality is this is an all-steel pipeline. And you may have, if you were to have leaks, it might be at like a gasket, at a above-ground valve or something like that. And again, we use gas detection equipment on a periodic basis, actually pretty much every time somebody's there, to look for leaks that would be substantial. But again, at 800 PSI, a very, very small leak makes basically, it will scream. It's not as just a little bit of some methane.
Essentially, you're saying that there's no way we can estimate the impact on the climate from this plant and the associated impact, because you're not going to be measuring methane losses and leaks.
But you do measure methane loss and loss unaccounted for from a measurement standpoint. But, you know, we're concerned both from a safety standpoint on methane leaks and on the value of the gas that's being leaked. Now, if you talk about the combustion, again, beyond the pipeline, beyond the burner tip, if you will, I don't know how that,
heat rate is very important to us. We don't want to be, first of all, we don't want to have leaks. That's just, it's not even like in the realm of how we operate. But it's very important to us as a power generator to measure our heat rate. So we'll be measuring the flow through the meter up at the tap location, and then how much we burn at the boiler tip. And we'll have a good understanding if we have any leaks, if we're paying more for gas than what we're actually burning. And we will be in full compliance with the Clean Air Act, and we will report all of our emissions, including any kind of greenhouse gas emissions, through the EPA website.
What do you anticipate your heat rate will be?
We anticipate it to be about 10,500.
We talked about feasibility, we talked about reliability, we talked about need, we talked about employment, and we talked about competitors. Do you have anybody in the region that would like to provide energy for this region more safely, with solar, wind energy, and where are they?
No.
Lady in brown.
What exactly is lighting regulation that is in this application in the newspaper? It's mentioned quite a few times. I thought it was a misprint, it might have been enlightened. But what exactly is lighting regulation?
Sure. Can I answer the question, please? The generators in New York a number of years ago were divested from your distribution utility. They don't own them anymore. So as part of that process, they all operate in the competitive markets that you heard the applicant discuss a few minutes ago. As part of that operation, in the interest of allowing them to compete against one another in that market, the Commission has adopted a lightened regulatory regime. So plants are not subject to sections of the Public Service Law that it would not make sense for them to be subject to. They are not subject to the rate-making sections of the Public Service Law because we don't guarantee them a rate of return. They have to get that through the market. There's a host of sections, and I definitely don't have time to go through all of them now, but it is not that they are unregulated. It's that they are subject only to those sections to which a wholesale generator, the Commission has decided, should be subject to.
Are those regulations readily available on?
Public service announcement.
Hi there, sorry to interrupt. Is there a Peter Martini present? Okay. I just have a small parking issue we need to refer to.
What I encourage you to do is take a look at the petition in this case. That's going to be the fastest way to take a look at what sections the applicant has asked essentially not apply to it. The Commission's regulations and statute are readily available on the website. And what I'll tell you, if you want to dig into it yourself, the original Commission case, it's called the Wall-Kill presumption. It's a Wallkill. That's the case that established the lighting regulatory regime.
And if you look at the petition that the applicants filed, you'll see footnotes to some other Commission cases. The Clark Street order is important, so you'll see that.
It's a large body of precedent on this issue, and not something that the Commission takes lightly. Back here.
Hi, I got a question. Can you share with us what government funds you've got? I know you're going after a grant, and I read someplace you got some federal money. Can you share the details of the money you've gotten from the federal government and the state government in order to implement this plan?
Hi, Mr. Gamble.
Hello.
We have not received 1 cent.
That was my message. You said you applied for a grant at one point in time. Is that true?
That is true. We applied for an economic development grant to help pay for people to get back to work, to help better this community.
And have you gotten it? So
We have not received that grant as of today. We have no assurances that we'll ever receive that grant. We just applied for a grant.
now there was a $14 million or $15 million federal grant that I read someplace. Can you?
That was back in 2006 from the AES. That was under the Department of Energy Clean Coal Initiative back in 2006. That helped us put in cascading low max burner, SCR system, mercury control, and a baghouse.
So you have received federal funds?
Not this, no, not Greenwich. Not Greenwich Generation. That was AES Greenwich.
Are you applying for any other state or federal income?
No. We have only applied for that economic development grant that you know well.
Okay.
I thought you were going to bring that to me anyway.
Bring what?
The economic development grant.
Not me.
Hi there.
Hi.
There's a geological fault line that runs right through Dresden, starting from way south of here, and there was an earthquake that was centered just a few hundred yards off the coast, off the shore of Seneca Lake in 2013, and I'm wondering what kind of safeguards you're planning on putting into this plan to prevent other earth-moving incidences that could cause unexpected leakages.
Joel?
I like pipeline questions. I don't know about anything on some stuff. So what we would do, if there was any impact on a pipeline, whether it be third-party damage, which is most common, or something, anything, whether it be an earthquake or a fire at the plant or sabotage or whatever, back at the source of the gas, which for us is at the National Fuel Tap, the valving that's there will have automatic actuators on it. And so if there was a leak on the plant, on the pipe or at the plant, the entire line would be shut in. Now, we do not have the capability, or I'm not anticipating any capability for automatic blowdown on that, which I guess you could do. However, they have a history of well leaking, but operating when they're not supposed to. And so it's much more common happening than because of an intentional shutdown. But we have automatic capability to shut that in. Both National Fuel would have that capability, and Greenwich would have that capability to shut the line down.
I have a question about where you're going to get the gas. Will it come from Crestwood, 20 miles, 19 miles south of here?
Not very. I've read some stuff. Now, Crestwood is a storage facility. And for us to utilize Crestwood, we would actually have to pay a fee to store gas. And it would probably be like we buy it in the summer, store it to the winter, and then take it out or store it till the winter and then take it out in the winter when we might use it. We are definitely, absolutely not thinking about that. And we absolutely have no plans in utilizing any storage facility because all it does is increase our costs. We're going to be competing on a market rate. We'll be purchasing our gas through a gas supplier. We are not going to be purchasing storage in this facility.
be sourced from there?
It will be sourced off of gas marketer that we will contract with.
So the Empire connectors flow gas both north and south. It could be Trans-Canada gas, Western Canada, it could be from the Marcellus, it could come off of any of the numerous pipelines that are all interconnected to Millennium, Empire Connector, Empire Storage down in Lighting, Tioga Storage, which is the line has been extended to. Much like the electric system, the power goes into, you buy gas today from one place and it's theoretically moved from one area to another. The reality is it's where electric pressure moves the pipe to gas.
I didn't really hear a yes or no answer about Crestwood, but it's my understanding that they supply to, it's connected with Millennium and some of those other pipelines. The Crestwood proposed 7-fold storage expansion plan, 19 miles south. It's my understanding they have plans and are connected with Millennium. So was that a yes or no answer?
I think the answer is first, I cannot answer for Crestwood's plans. Second is, I am not engaging, and the buck stops here with me. I'm the decision maker. I am absolutely saying, no, we're not planning on using Crestwood's facilities now or in the future. Is that, can I say, is that good? Okay. Why just make sure you're, yes?
Yes, I have a question, Mr. Irwin, about the extraction of water from Seneca Lake. Cayuga operating, the Cuba plant extracts 245 million gallons a day, and they're 305 megawatts. Your facility is going to be at, I believe, 105 megawatts, and yet you're planning, or at least you want to be licensed to extract, I think it was 195 million gallons a day. That sounds like your cooling system is a lot more inefficient, so if you could comment on that. Maybe about the numbers.
Yes, yeah, I will. First, okay, I'll answer that question and if you have a follow-up question. Just so, I'm simple, so I gotta do these one at a time. All right. Can't speak about Cayuga, I just don't know. But I know for a fact that we're permitted to discharge or withdraw and discharge 190 million gallons a day. Right now, I can do that. But physically, it is absolutely impossible with the technology, with the pumps that we have installed to do that. We can only, and we will only, withdraw around 60 million gallons per day when we're operating and return it to the lake. It only goes through, it passes through a tube and shell condenser and right out to the discharge.
So another part of my question has to do with wet wire screening. That is the best technology is now required for plants to have that in place to reduce entrainment problems, aquatic biota being pulled into the system and killed. And do you have the wet wire screening in place? And if not, when will it be there?
The BTA determination for the facility is wedge wire screens as the best technology available for the plant. There's a series of things we have to do that, and it'll be completed in this present permit cycle that runs 5 years. We actually have to do some upfront studies to make sure that the wedge wire screen technology will work in this application. We feel that it will, then we have to design, engineer, procure, and install, and we plan to have that installed in 4 years. And the cost of the facility will be about $5 to $7 million.
And just the last part of the cooling water, I believe your discharge permit allows you to discharge at up to 108 degrees in the summertime. And that sounds like a mystery.
That's what the permit says, but in all actuality, it doesn't matter if the water's 30 degrees, 40 degrees, 50 degrees, 90 degrees. The differential temperature from the incoming to the outgoing is going to be 12 degrees. We have extensive, this is something we measure on a daily basis, and we have extensive background information or historical information It is what it is. We only have a certain amount of BTUs to take out of the steam. We have a known flow going through the condenser, and it's 12 degrees up.
Do you have a quick question? Because it's 7 o'clock. I'm actually going to suggest maybe, did you sign up to speak?
I did.
Okay, and what's your name?
My name is Mel Russo.
Okay, and the gentleman in green?
My name is Joseph Wetmore.
Okay, did you also sign up to speak?
I have not yet.
Okay, what I'm going to suggest, because I have at least 55 people that want to speak, I think we have to start on time if we're going to have any hope of getting out of here within 2 to 3 hours, if we're lucky. I'm going to suggest that maybe the company and staff person will talk to you in the next room if you like, but I'd like to get the public statement hearing started so that we can hear from everyone. Is that all right? If those individuals wanted to talk with either company or staff?
Can others of us do that as well?
Yes, if you like, but I'm going to start the public statement hearing, so I will call names. I just feel like we have to get on the record in order to hear from people.
Yeah, I just want to thank everybody, and, Greenwich is not like the typical industry here. We are part of the family, we're part of the Gates County family, the town of Torrey family, and I invited Mr. Gamba and Mrs. Gamba, the council for Finger Lakes to visit the plant. The Schuyler County Environmental Management came and visited the plant. We are not a closed facility. We are open, we are proud of what we do, and hopefully everybody can come and see everything.